Good afternoon and welcome to this Grattan Institute webinar on how to stamp out the exploitation of migrant workers in Australia. We're very grateful you can join us today. My name is Brendan Coates. I'm Economic Policy Program Director at the Grattan Institute and Grattan's lead on migration policy. I'm joining you today from the lands of the Wurundjeri people of the Kulin Nation and would like to pay my respects to elders past, present and emerging. In any discussion about migration, we should never forget those that came here first. And it's why we soon hope that we will see constitutional reforms to empower Indigenous Australians to, in the words of the Uluru Statement of the Heart, take their rightful place in what has always been their country. So joining me in this webinar today to discuss the issue of the exploitation of migrant workers in Australia are some of Australia's leading experts on these issues. So first, I'd like to introduce Joanna Howe, who is Professor of Law at the University of Adelaide and a consultant with Harmer Workplace Lawyers. She's an expert on the legal regulation of temporary labour migration. And in 2022, she was appointed by the Minister of Home Affairs as part of an expert panel to review Australia's migration program, a review that's recently been published. Good morning, Joanna. With me as well is Allan Fels, who is Professor of Law and Economics at the University of Melbourne and Monash. He was chair of the Commonwealth Government's Migrant Workers Task Force. He was also chair of the Australian Competition and Consumer Commission and its predecessor bodies, the Trade Practices Commission. Allan was also the Foundation Dean of the Australian New Zealand School of Government from 2003 until 2013. Welcome, Allan.
Thank you.
Thank you. And finally, we have Sharmilla Bargon, who is a senior solicitor at Redfern Legal Centre in Sydney and the coordinator of the Employment Rights Legal Service, a partnership with the Inner City and Kingsford legal centres that provide free legal advice to migrants and other vulnerable workers across New South Wales. Before Redfern Legal Centre, Sharmilla mainly worked in corporate law with 1 year at the Migration and Refugee Division of the Administrative Appeals Tribunal. So good morning, Sharmilla. So we've seen a series of high-profile media investigations on the issue of the exploitation of migrant workers in Australia that suggested that the underpayment of migrant workers has been widespread, and also that more serious instances of exploitation, such as bullying, sexual harassment, and unsafe workplace conditions, has been a big problem in Australia. Last week, Grattan Institute published a recent report, our latest report on the exploitation of migrant workers, which confirmed that the issue remains widespread. It's a problem that continues to beleaguer Australia's migration program and has serious implications for Australian workers as well. So that work found that up to 16% of recent migrants are paid less than the national minimum wage, compared to 9% of all Australian workers. And those figures, while they were down from before the pandemic, reflecting the fact that fewer temporary visa holders are here and the labour market is the strongest it's been in 50 years, there's a big risk that those numbers will rise again as migrants return. We also found that recent migrants are 40% more likely to be underpaid than long-term residents, even accounting for the fact that migrants tend to be younger, working in less skilled industries like hospitality and agriculture, where exploitation is more common. So this is a serious problem. And the Albanese government has also commissioned a report from Victorian Police Commissioner Christine Nixon to investigate the exploitation of migrant workers and exploitation of Australia's visa system. That report is yet to be made public, but reportedly identifies systemic failures in the regulation of our visa system and some of the issues that we're going to discuss today. So to kick off the panel discussion today, I'd like to start with you, Sharmilla. At the Employment Rights Legal Service, you see cases where migrants have been underpaid or exploited in other ways every day. What are some of the experiences of migrant workers that come to the Employment Rights Legal Service? And just how harmful is underpayment and exploitation generally for migrant workers?
Thank you for that, Brendan. Before I answer that, I would also like to acknowledge that I'm dialing in today from the land of the Gadigal people of the Eora Nation, and that our vision for reconciliation is for a society in which Aboriginal and Torres Strait Islander people and other Australians can live and work together with mutual respect and understanding, free from discrimination and harassment at their workplace and in their lives generally. So new migrants face so many additional barriers when trying to find work and to access the legal system and enforce their legal rights. Many migrant workers don't understand their rights at work, or they're not supported to enforce them. So people on temporary visas most commonly come to the Employment Rights Legal Service, or ERLS, for advice about underpayment or non-payment. So underpayment comes in a number of different forms. We really commonly see people getting paid a flat rate, which is under award. And for some perspective, the national minimum wage for casual workers sits just under $27 an hour. And we regularly see people that are getting paid $12, $16 an hour flat rate. We also see that superannuation is somewhat a fiction at best, shown as paid on pay slips, but with no transfers made to super funds. We also see forced cashback schemes where employers pay our client the correct rate into their bank account, so records look compliant, but then employers are marched to an ATM and forced to give their employer cash, sometimes ostensibly because they're paying back a loan for visa application fees. And we very regularly see a sham contract type situation with the miscategorization of employers as independent contractors. So it is also really worth flagging that exploitation comes in many forms, and we see cases of compounding vulnerabilities where all of those same factors that silence underpaid workers and stop them taking action also stop migrant workers from taking action against more sinister conduct, such as discrimination, sexual harassment, and assault, and it compounds the harm done by workers. So exploitation is profoundly harmful to migrant workers. Our clients are regularly left in precarious financial situations and they face homelessness. We see clients that are forced to skip meals. This level of stress can obviously impact on people's mental health and their trust in Australia's legal structures.
Thanks, Sharmilla. Yeah, certainly our work as points to the issues around underpayment with respect to the national minimum wage, but there are many other forms of underpayment, other entitlements that people aren't being paid, their superannuation, their leave, as well as those other forms of more serious exploitation where the power imbalance that people face leads them to end up in some pretty bad situations.
Indeed.
So when we're thinking about migrant workers, how does their visa status affect their willingness to come forward? How big an issue is that in leading to the kind of outcomes that you're seeing every day?
So our clients regularly tell us that their visa is everything. People invest years and thousands or even like hundreds of thousands of dollars into the Australian education system, sponsored skilled working visas, and international students fear that their visa is going to be cancelled by Home Affairs if they work over their 40 hours a fortnight where their session is active. And sponsored workers fear reporting their exploitation because it puts their sponsorship at risk and it could cause them to lose their visa. I've never talked to an international student that doesn't know the work conditions on their visas. And in many ways, these workers know a lot about the system that they're working within, but many of our clients just accept wage theft. They tell us that they aren't willing to risk their pathway to permanence or getting their uni qualification on the chance that they're going to recover underpaid entitlements. So they're not willing to risk that because it's a complicated, lengthy legal process with an often uncertain outcome. At the end of the day, visa is everything.
Thanks, Sharmilla. So, Allan, when before you were appointed to the Migrant Workers Task Force, you were originally running an independent panel to assess underpayment claims that came through the 7-Eleven scandal about 7 or 8 years ago. So can you tell us about the experience when you were chairing that panel? What actually led to so many migrant workers coming forward and seeking support at a time, as Sharmilla's mentioned, they are worried about their visa status and that compromising their ability to come forward and actually report underpayment without risking their visa and their place in Australia?
We weren't government. We made it clear we would not be sending on anything about their visa to immigration or to anyone else. We worked extremely hard to build up trust by having our own social media connection with people who could come forward. We did build up their confidence by the fact that we got some fairly big paybacks early on, and then we spread the word and the word spread, with the result that before we were closed down, we'd got 160 million in refunds. And there's a very interesting point there that sanction 160 million repayment far exceeds the sanctions available as a result of fines.
So we're in a world where the employer isn't really facing really strong sanctions as a result of the underpayment itself. But was the actual having to repay that money, was that a big penalty or motivator for 7-Eleven? Is that a one where that actually discouraged them to actually change their game, fix up the problems?
Yes, as time passed, it became clear they were very unhappy with the amount of repayment they were making, and that's why I got sacked. And the original idea for the inquiry was there'd been a big scandal, Adele Ferguson, Four Corners, and they thought they'll get some independent guy and arrange a few repayments, maybe 10 million. But I and my colleague David Cousins went in a bit harder. We got the payroll for the last 10 or 12 years and found about 20,000 people that had been clearly underpaid.
So, Allan, then you obviously went on to chair the Migrant Workers Task Force. So after you were fired by 7-Eleven, you were hired by the federal government to look at these issues. How would you describe the problem? What is the problem that we're trying to solve here when it comes to trying to get to stamp out this kind of behaviour?
Well, yes, let me make a general point. This is this so-called framing issue. How do you frame the policy problem? Now, there's a whole lot of ways and they have a big effect on policy. One way is there are these foreign guest workers that come in, break our law, put Aussies out of jobs and so on. Now, that influenced quite heavily the way in which the Australian Border Force and immigration went about enforcing the law. They chased students breaking the law. Another way of looking at it is that the franchisees, the little 7-Eleven shop franchisees, were breaking the law. So then you go for them. Another one is the 7-Eleven general franchise agreement with all their little shops forced them to underpay. It was built in to the 7-Eleven model that there'd be really low wages through underpayment. From that point of view, go for 7-Eleven. Another theory is that the law enforcement by the FWO was no good. Yet another is that the minimum wage is too high, and that's the cause of it. And then you turn to all the questions which actually are very well dealt with in your report about all the immigration policy drivers that influence the situation. And clearly part of the answer, the important part, as you've brought out, is to have a careful look at the immigration laws. And you can also look at education and what role education institutions could play, and are they just trying so hard to get students they don't care about the fact that they're exploited. And then there's agriculture. You know, farmers tend to think they've got a bit of a golden right to pay nothing, and they tend to be supported even by the agriculture bureaucrats and so on. And there's also we, greedy consumers, we want low prices. So I just want to make that general point that framing of the problem is quite important. And then in regard to my work, for various reasons, we were told to do the law enforcement bit. We could see the broader issues, but we're rather strongly discouraged, in particular from the issues that you, the Grattan Institute, have brought up about the migration policy drivers.
I've just realised I was on mute. Apologies all. Thanks, Allan. So that's where I want to go now, actually, is the question about what about the migration system is actually contributing to underpayment of migrant workers, how does it make them more vulnerable? So, Joanna, I want to come to you on this. You've done a lot of work on this for a long period of time before you were appointed to the recent migration review. Now, that review, one of the chapters of the review, chapter 9, is very clear. Current settings in the migration system heighten the risk of migrant worker exploitation. So can you talk us through what are the settings at the moment that make migrants more vulnerable? What visa rules do we need to be thinking about if we're going to be trying to fix the problem on that side?
Okay, so I think the important thing to acknowledge right up front is that the migration system, when working well, is something that really drives our economy and our prosperity. And I think many of us in this conversation are probably immigrants or children of immigrants, and it's part of what makes Australia successful. And what we're talking about today, I think, is the fact that we have allowed our immigration system to drift and for temporary migration to become the mainstay without the necessary assessment of the consequences of doing that. And I think a starting point in the review is a recognition that by virtue of a migrant's temporariness, they're vulnerable. And we had long debates about that. Is that consistent across the board, or are low-wage migrants more vulnerable than high-wage immigrants? And, there were lots of discussions, because obviously if someone's being paid a higher wage and they have a higher skill level and a longer education, then it's probable that they have more ability and control over their circumstances in the labour market. But one key driver that we did identify as a contributor to inviting exploitation is the sponsorship in the old 457, now 482, that's temporary skill shortage visa. And I think when this was designed in 1996, coming out of the Roach Report, we didn't envisage that sponsorship would be a problem, because the 457 visa was designed as a discrete, highly skilled program that would bring in the best and brightest from around the world. And what we saw happen after sort of the early 2000s is that this visa expanded and became a general labour supply visa. And so it brought in workers across the skill spectrum and across the wage spectrum. But that the very nature of sponsorship gave employers, if they wished to use this for unscrupulous ends, it gave them more leverage. So the employer wasn't just controlling the workers' employment, but they were also in effect controlling their passport, because workers only had 28 days to find a new job before they would have to leave Australia. And the data shows that for an Australian worker who has, the benefit of English language, community network, secure housing, it actually takes 3 months to find a new job for an Australian to transition. So the fact that we were giving people from overseas 28 days is effectively bonding them to their employer. And I think in the Grattan Institute report and building off the migration review, one of the key things we're seeing is an emphasis on portability. So the fact that these workers should be able to move between employers and to have enough time to do that. So in the review, we suggest 6 months, but it could be longer, because I think one of the fundamental things is our immigration system has outsourced the identification of labour market need to employers. And so we had a system where if an employer put their hand up and said, I can't find the workers I need, they could then go overseas and get a temporary migrant in. But what scholars like Chris Wright and Stephen Clibborn and others have shown is that employers might have a variety of motives for bringing in an overseas worker, and creating a compliant workforce, it can be a motive. So making sure that the identification of labour market need is done properly is important. And what it means then is you don't need to tie the worker to the job, because if you know there's a need in the labour market, then giving them portability means they'll be able to move to other employers who have that same need. Now, I have had employers say to me, including the small business community, saying that they are concerned because they want to be able to bring in a worker and retain that worker, because there's lots of costs associated with bringing in workers from overseas. And I think that's a valid point. But I would say that there are ways that we could do this more flexibly through moving through a monthly sponsorship model. And I think the fundamental point is to say that Australian employers have no security over Australian workers. They have to do their best to retain those Australian workers. And so why should employers have more control over an immigrant who's here on a temporary basis in order to be able to keep them at their employment? They should have to do they should have to face the same competition that they do when they hire locals. Otherwise, there are additional advantages to hiring temporary migrants. And then that is a concern in terms of the integrity of our labour market.
Yeah, because the big difference, like the one big difference between Joanna, between, say, hiring someone who's here, so if I hire my staff here at Grattan, or sponsoring a worker, is those additional costs. So there's an extra $3,000, $4,000, $5,000 in sort of upfront costs at the moment. You would move to a model where those upfront costs are defrayed over the course of the time that the person is in Australia. So 2 or 4 years, depending on the length of the visa. And therefore, if they switch employers, they should be able to do that quickly. They should be able to, the new employer takes up basically the cost of those sponsorship arrangements for the period where they're hiring that worker or have that worker being employed for them.
Yeah. That's correct. And I think we should acknowledge that under the old system, small business was effectively locked out because the upfront costs were so high. So if we move to a monthly sponsorship model, we're actually opening up the migration system to more employers, and that's a positive thing. I think a second driver for temporary migrants in terms of being additionally vulnerable in the labour market are also things that, like visa conditions that restrict the way they work or tie an employment outcome or migration outcome to the performance of work. So I guess, in the report you flagged the 88 days, and I think we know we've known this for a long time, that the horticulture industry's reliance on the 88 days has. So,
Joanna, can you just explain for those that may not be as across the visa system what the 88 days is?
Sure. So the 88 days, it was an invention in 2004 by the Howe government that if a backpacker came to Australia and did 88 days of specified work in a regional area, and typically 90% of people did that through working on a farm, they would get a second year on their visa. And, we've seen a lot of research and also media exposés show that this is a primary driver of vulnerability for backpackers because it ties a migration outcome, the ability to get a second year on your visa, to the performance of work. So again, it gives an employer additional leverage that they wouldn't have. Now, I've done a lot of research in the horticulture industry, and I want to say up front that there are very good employers in that industry who actually really struggle with the fact that their industry has this reputation of exploiting workers. But the reality is the 88 days doesn't help that industry. It doesn't give them a sustainable pathway for temporary migrants to accumulate skills and to be invested in that industry. It just gives them a revolving door of backpackers. But I think the industry itself has struggled to sort of, sometimes when if I gave my kids access to the lolly cupboard, they would just take the lollies out, and I have to have restrictions around what they're able to eat. And it feels a little bit like that with agriculture. Like, they know that this is not in the best interest in the long term for their industry, but they kind of got their hand in a lolly jar, and they've got this supply of backpackers that just come through. But I think, as your report recognises, as the review does, if we want to have migrants doing work for a sector like that, it shouldn't be done through this revolving backdoor of backpackers. And similarly, in the international student visa, there's a condition around 40 hours per fortnight that they're allowed to work. And if they breach that, then they're liable for visa cancellation and deportation. And I think the research has also showed that conditionality does create challenges. But equally, as the Grattan report notes and the review notes, this is a really difficult issue because the international student isn't a work visa, it's a student visa. And so if we were to just give unlimited work rights, like we did in the pandemic, there's potentials for that visa to just become the de facto low-skill work visa pathway into the economy. And so I think the right thing to do is what we asked for in the review and what you've asked for, which is a greater look at this. The government really needs to have a proper review commissioned into the international student visa. And Allan's point about the sector's reliance on international students is kind of like cash cows. And again, that's something that we need to be looking at properly, that if we are funding research through international student enrolments, then what does that say about the way we prioritise research in our country, but also what is it doing to the quality of education for domestic students as well?
Thanks, Joanna. So, Allan, just to pick up on the student visa question, right? Because the Migrant Worker Task Force reports also identified this as a cause, and certainly your work with 7-Eleven identified as this as the limitation on work rights for students as a cause of their vulnerability to being exploited. How do you think work rights should be reformed? Should they be unlimited, noting the issues Joanna mentioned, or is there some other way which we can try to square the circle to reduce the vulnerability of international students to being underpaid in Australia?
I'd probably hesitate to remove the rule. And I think what we've heard from Joanna and you and all that is about right. It's an insoluble problem. I did think, however, that there are some surrounding details, such as that the universities should do a lot more, and TAFE and all the others, to, in effect, keep a bit of a check on the students. For example, if they're just working more than 40 hours and perform badly, then some steps should be taken about that. So there's a bit of scope for action by the tertiary education institutions, who generally have a very little interest in the issues of student exploitation.
Well, that's one of the things that we've heard about the Nixon review that's currently unpublished, that something like 15% of all student visa holders in the vocational education system withdraw from their course and then fail to re-enroll in other courses. So in the course of us seeing students being underpaid while they're trying to do their work, we also see that issue around some people using this visa, the student visa, as a de facto low-skilled work visa, leading to sort of some of the more nefarious outcomes that have been exposed in various media investigations over time. So do you have any sense, Allan, of what that would look like? What responsibilities would you want to see? Have you thought about what responsibilities you want to see put on international higher education providers to try to make them step up and take more responsibility here?
Yes, I'd like to see on-campus personnel at these tertiary institutions being set up to be available to deal with students who may be being exploited, to educate them, and a whole lot of things like that. And the other aspect is somehow, and I can only say it broadly, keeping a closer check on badly performing international students. You should do that anyway, but particularly if it's linked to work. I just wanted to mention one other variable. I believe in some countries, maybe France, there's an absolute prohibition on working if you're a student. Now, Australia considered that, but from the point of view of being internationally competitive in terms of being of interest to students, that would lose a large part of our student population. So that one's not really been considered. And as we just heard, how you fiddle the exact 40-hour rule is a little bit unclear.
So one of the things that we've thought about is to go from a fortnightly cap on hours to an annual cap, because that would at least reduce the number of times a year that an employer is actually that a worker is at risk, a student is at risk of breaching their visa conditions. And often those breaches seem to occur early on. The concern is if you work, let's say for 7-Eleven for 30 hours a week for a couple of weeks, you've breached your visa condition, the employer has a way, it basically has you over a barrel from then on. So that's the sort of thing Grattan would like to see as part of this process. But I agree, we have to do it tied in with trying to see how the international higher education system as a whole can help as well, because the only country we have found that has no restrictions on work rights is Sweden, and in that country, students are required to be studying for 40 hours a week. We haven't seen, most other countries offer work rights for about 20 hours a week, 40 hours a fortnight. Australia was actually sort of an outlier in uncapping work rights during the pandemic. Now, but we've talked about some of the visa rules that make migrants vulnerable: sponsored workers, students, working holiday makers. Sharmilla, I wanted to come back to you though, because the Redfern Legal Centre has also been advocating for stronger visa protections for migrant workers beyond individual visa changes, and particularly the idea of a migrant justice visa to basically provide people the opportunity to stay in Australia and make claims for unpaid wages. How would that visa work, and are there other protections that migrant workers also need?
The short answer to that one is absolutely. So Redfern's had an international student legal service for a number of years. We've been mooting solutions to this for a little while. As we've flagged, visa exposure is a key issue. And what we have to address first is that there is no current effective visa protection solution for temporary workers that allow them to take action against their employers. So the Migrant Justice Institute and the Human Rights Law Centre have developed a detailed proposal for new visa protections for migrant workers who have been exploited at work. And Redfern was one of 40 organisations across the country, including Grattan, that has supported their proposal. So this proposal set out in your report, the Grattan report, and has two elements. So there's an exploited worker visa guarantee, which will protect visa holders like students from visa cancellations, and a new workplace justice visa. So this visa would be a visa of up to 12 months for migrant workers whose visa would expire or be cancelled because they come forward with a claim to recover wages. So both of these elements, the protection from visa cancellation and the workplace justice visa, require the migrant worker to demonstrate that they have a meritorious and non-trivial claim for breach of labour law. And then this must be certified by either a government authority, such as the Howe, health and safety authorities, or be certified by an employment lawyer such as myself. So someone from a CLC or a union or a lawyer in private practice who is an employment specialist. So currently there are really big issues like Home Affairs does provide limited protections against visa cancellation for workers who go to the Howe. So this visa amnesty or assurance protocol between Home Affairs and the Howe it's problematic. It's also really rarely used, partly because it requires workers to take on the risk that they would come to the attention of immigration officials, and partly because they're not certain that the Howe will apply it to their case. So we've definitely seen in our caseload that what happens when our clients don't get protection from the Howe after they've gone to the Howe, disclosed information, putting her at risk. And so in our experience, the assurance protocol can actually make things worse for a migrant worker. So what we really like about the proposal is that our client in that instance that I flagged wouldn't need to go to the Howe, but they'd be able to get visa protections through services such as ours with more assurances that they'd get the protections that they need.
And I suppose, Sharmilla, because the requirement is that you can't just claim these protections at a whim. You've got to have proof that there's got to be a reasonable case. There's got to be some assessment by, a workplace law practitioner such as yourself or the Ombudsman or others to show that there's a reasonable case here. It's not like the situation we see where people get off the plane, claim asylum, claim, refugee status, and then end up working for 12 months because they're waiting for the case to go to the AAT. And so we don't think we would see those kind of outcomes in this instance.
There's a number of inbuilt mechanisms to prevent against abusive process, which is absolutely recognised as a live issue. And so those protections are trying to balance a number of factors.
No, that makes a lot of sense. And certainly, we are a big supporter of those visa changes, which we think would make a difference. Now, I want to switch from, and we're glad to see you are too, Allan. And so I want to switch actually now from, we've talked a lot about migration, but one of the things that really was quite striking for us in doing our own research on this issue was that underpayment, so there's obviously many forms of exploitation, but underpayment in particular, we always thought it would be a big issue for migrant workers of all the previous work that's been done by those on the panel and others. But what really surprised us was the high rates of underpayment of Australian workers as well. So, 1 in 11 Australian workers were paid less than the national minimum wage, which is about $21 an hour for full-time workers or part-time, and about $26, $27 an hour for casuals. And sitting behind that was the surprising finding for us that the workplace regulator, so the cop on the beat, the Fair Work Ombudsman, and the broader regulatory regime was not leading to a lot of deterrence for employers against underpayment. So we were finding only $4 million of penalties were levied on employers for underpayment of workers in 21-22. By comparison, the ATO collected $3 billion in penalties on those that cheated on their taxes, and the ACCC levied penalties, court-ordered penalties alone of $232 million for breaches of competition and consumer law. So, Allan, this is a question for you. As a former head of the ACCC, are we taking the enforcement of these workplace laws seriously enough?
No. There are two aspects. One is that the FWO over time had a culture of not applying the law as seriously as it should have. They have tried to lift their game in recent years, but I'm not sure they've quite got the culture of, say, the ACCC in terms of tough law enforcement. But in some ways, the bigger problem is that with the best will in the world, it is difficult for the regulator to get results under the current law. Going to court is quite difficult. And then even if you get a verdict, then chasing damages or restitution is another massive problem. So the obstacles under the present legal system are very big. We should be thinking about looking at some sorts of approaches that make it easier to get fines and penalties. We particularly emphasised having a look at small claims tribunals and their processes and so on, which are much more flexible, easy to operate and get results.
Thanks, Allan. We'll talk about the small claims process in a moment. Just so sticking with the question of the enforcement regime, it is obviously difficult to take people to court. Something that's always struck us is the ACCC has the power to issue fines itself as a regulatory agency, and then obviously those can be challenged in court and enforced by the courts if those that are being hit with those fines disagree, they can challenge them. Were you surprised that the Ombudsman doesn't have the ability to issue, infringement notices without going to court for anything other? That they can issue them for not keeping pay slips, not keeping records, but they can't issue them just for the underpayment itself?
No, they need infringement notices. There are some limitations on what you can do with them. The ACCC negotiates big fines, which are appealable to court, but it's also got a lot of credibility. The FWO doesn't quite have the credibility that the employer is going to buckle to big demands by them. So that brings us to the whole culture problem. It's just a widespread culture of underpayment. And when I heard Sharmilla at the beginning reciting her list of concerns, it was exactly what I heard 5-6 years ago, and it's been no progress. And that concerns me. And as I think you mentioned, the problem will now get worse with more migrants. The one big deterrent I'd like to see there is criminal sanctions for serious, systematic, deliberate underpayment. That would have, in my view, a considerable deterrent effect compared with anything else in the law. And I understand the government is going to legislate that. It was proposed in, I think, the end of 2018, and then nothing's happened. But now it is looking like it's going to end up in the law. That'll help.
That's certainly something that we support as well, Allan, is providing criminal penalties for wage theft where it is knowing underpayment of workers, but along with stronger civil penalties as well. I just want to return back to Sharmilla. What changes would you want to see in the enforcement of workplace law to assist you in the work that you're doing to help migrants, to discourage employers from underpaying workers, including migrants, and to help them get the repayment of those unpaid wages after the fact?
So, like Grattan and Allan Fels, we would support the criminalisation of wage theft, but we'd also very much flag, because it signals how seriously government and society takes these contraventions, but foundationally, so much more energy has to be put into measures that respond and address to the underlying causes of exploitation that we've talked about today already. And a lot of those are flagged in the Grattan report. But coming back to the Fair Work Ombudsman and culture, first of all, the FWO is filled with good lawyers. They do good work and they do a lot of it. But the issue is that the FWO doesn't always and may not be the most appropriate place for individual recovery. The FWO is concerned with overall workplace compliance. It isn't an advocate for individual complainants. And so while increasing penalties to the FWO will absolutely help, it only goes so far. So some of the things that are being talked about in terms of reform to the FWO would be that the FWO pays unpaid judgment amounts to affected workers and then seeks reimbursement by enforcing the debt against employers. That's definitely something that's being talked about. And for advocates like us, we often have an issue at the enforcement side of things due to phoenixing and supply chain shadowy practices. Enforcement of final orders could be really tricky. But again, we really have to flag that a lot of our clients aren't going to go to a government organisation full stop, whether the FWO or otherwise, because they're concerned, again, that this is going to expose their visa position. So foundationally, in terms of workplace law and enforcement, increase funding for migrant workers centres and community-based legal services such as the Employment Rights Legal Service would go a long way. So we are specialists at providing advice to vulnerable migrant workers, and we do so in a culturally safe way. So it's absolutely our position that the government should provide recurring dedicated funding to CLC providers and migrant workers centres to help with enforcement.
No, that would certainly make a big difference, and it's something that we support as well. The presence of non-government actors, third sector actors in this seems really important, and certainly we would support migrant worker centres in each state, stronger funding for community legal centres as basically ways for migrant workers and Australian workers to be able to seek repayment. I should also note, Allan did mention beforehand he did have to duck off at about 12:45. So Allan, if you do need to duck off, thank you very much for joining us for the panel so far.
And I'll just underline what's just been discussed, that some of these extra measures, such as support for community legal centres, to be brought about by the fact there's just a culture of underpayment and reliance on traditional law enforcement methods, even souped up a bit, is not going to be enough. That's why I'd support any sort of broader imaginative things, together with careful adjustment of the immigration law.
No, thank you very much, Allan. They're great points. Thank you for joining us today.
Thank you.
Now, Joanna, Allan makes a really interesting point that it's not just going to be changes in the official government arrangements that are going to see underpayment reduce for migrants and Australian workers as well. A surprising finding of our work when we looked at the drivers of underpayment was that non-union members were 65% more likely to be underpaid than union members in the same job with the same skills and the same age and so on. Unions have historically played a larger role in enforcing workplace laws. Should unions also be playing a bigger role in enforcing workplace laws again, as they have in the past?
Look, I think this does go to the fundamental change that we've seen occur over 2 to 3 decades in Australia. So if we remember when we had Prime Minister Howard, and his thesis was you don't need collective organisations to be enforcing workplace law. You can create an independent body, statutory body. And so he created the Office of the Employment Advocate, which has now become the Fair Work Ombudsman. But what I think we see the effects of that is you've replaced having collective organisation across the labour market in all different sectors in a geographically dispersed nation like Australia. You've replaced that with a central body that maybe has some offices in key regional centres and capital cities, but just doesn't have the reach or the intelligence gathering capacities or the manpower that a collective enforcement of rights is able to achieve. And so I don't think it's any wonder that we're in this situation today where the FWO is really just scratching at the surface, because that's all they can do. And I welcome your suggestion for greater funding for the FWO. I think that obviously needs to happen. They need greater powers. We need to increase the penalties. But I fundamentally agree with, what Sharmilla said and what others have said, which is that we need to actually be driving funding and support and recognition of non-statutory actors, third parties, such as unions, community centres, etc., that can draw attention to this. And, a key example is I've got an Australian Research Council grant to look at undocumented migrants on farms. And I've been travelling around the country speaking to undocumented migrants and getting their stories. And I asked them the question, because they tell me these horrible stories of their experiences, particularly being hired by contractors and being put on farms and working for terribly little amounts. But, you ask them, do you know who the Fair Work Ombudsman is? And universally the answer has been what? Who? And they just don't even know that actor exists within the system. But then secondly, they would never dream of going to the Ombudsman. Once I tell them who the Ombudsman is and what they can do, they just never dream of going to them because they know that they're government, and it's just not an option for them, and it's also not an option for other temporary migrants that have other different ambitions and concerns here. So I think it's just really important to recognise that the FWO is part of the solution, but it cannot enforce workplace rights across the board, and we do need unions. There's a role for unions, and particularly for migrants who have a whole raft of concerns around further stay and other vulnerabilities. You need that non-government actor.
No, we really strongly agree with that. So, Joanna, certainly when we're thinking of migrant worker centres, the existing migrant worker centre historically has been union funded. We would probably think of a migrant worker centre funded by government that's not explicitly union run, but has strong links with unions, existing supports like yours, Sharmilla, to potentially stronger supports into the links into the universities to help support students with underpayment as well. It is an issue when you come from a country where maybe you have less faith in your government, for one, but then two, in a world where one arm of government is responsible for enforcing workplace laws and the other arm of government is responsible for enforcing your right to stay in Australia and your visa conditions, you're always going to be pretty reluctant to go and speak to government in any form as a migrant worker to sort of seek redress for the kind of experiences that you're seeing through your own research. One thing I did want to raise with respect to the role of unions is the report, the Migration Review, does point to the potential for a tripartite approach in the design of visas or in the approval of visas. We've seen an example of this, it seems, play out already in this response from the government, in that you mentioned before that temporary sponsored work has historically been and originally was envisaged to be highly skilled. Grattan's work has shown that over time, it's increasingly become less skilled. The wages of those workers has been lower because the minimum wage threshold has been stuck at $54,000 a year, and that's obviously full-time work. That's much lower than most full-time workers earn today, and it hadn't been indexed for a long time. It's now been raised to 70,000. But at the same time, we're now seeing concerns around being able to fill workforce shortages in areas like aged care, childcare. These are jobs that pay much below 70 grand a year. And the government's established a new labour agreement for temporary sponsored workers in aged care, where if employers want to access sponsor workers through that process, they have to sign a memorandum of understanding with the relevant union, including provisions for things like providing union-led inductions for migrant workers and their rights. Is this the kind of model, when you thought about a tripartite approach, that you were thinking of, that the government is now implementing to try to reduce underpayment and the risks of exploitation amongst less skilled workers?
Yeah, I think it is. I think the aged care labour agreement is really exciting because it brings together the different parties that have a vested interest in this, and it puts it on them to think about how to solve this problem. And so with the aged care sector, we know that there are these long-term workforce needs that just aren't being met here, but we also know that there's a problem with local workers in terms of being retained in that industry. It's a revolving door. They don't stay in the industry. They often have, paradoxically less hours than they would like to work, and they work for more than one employer. So it's an industry typified by insecure work. So the idea that you would just then open a front door pathway without any checks or balances to overseas workers to work in aged care, it would just invite all the problems that we've seen over the past few decades in particular industries. So I think it's been very wise of the government to get the parties together to resolve this, and the solution that they've come up with through requiring employers to have a positive obligation to deal with the union, and then the union can talk with the existing local workers about what their problems and needs are, and as part of that, migration is one of the solutions. But it's a bigger question around how work is organised and managed for that employer. So I think that is a positive thing, and taking a sectoral approach is the right thing. And again, an industry like agriculture, which for a long time has been also calling out for overseas workers and for a dedicated visa, I think a sectoral approach is the approach that would be the only one that works, and it would have to involve the unions, because as an industry, there are concerns about structural endemic non-compliance with labour standards. So you can't just open up the door and create an agriculture visa, which the last government announced and this government has said they're not going to do. You have to take this kind of tripartite approach to resolve some deeply entrenched problems that particular sectors like agriculture and like care are facing, and hospitality would be another one.
Yeah, it'll be really interesting to see how that plays out over time, because we have this issue of shortages in the aged care. Grattan's perspective is a lot of that needs to be solved by paying those workers more. We've underpaid those workers. That's it. Government is the funder. The providers can't change their prices, so you end up with a situation where we don't see wages rise and we end up with seeing shortages. And it is interesting to sort of see that play out now in aged care with the onset of this visa, to allow people who are often a little bit less skilled to be able to seek, or they are less skilled jobs than, say, tertiary qualified jobs or skilled trades. They require vet level qualifications. One concern that's been raised is that's going to lead to a lot of international students basically just jumping on this as their pathway to seeking permanent residency, because it does offer the prospect of PR at the end of it, and that we'll see a repeat of what we saw a decade ago, where you see poor quality education providers making the most of the fact that there is a pathway to PR for undertaking certain courses. Is that something you're concerned about here as well?
I think we need to have checks and balances in the system. And in terms of education providers, I think we need to have far greater regulation on who can set up shop as an education provider. Something we noticed in the review is that there's a significant number in the vocational sector that have a small amount of students. And so I think there are questions around the quality of the education that might be occurring there. It's not necessarily just about size, but I think that's important, that we need to be regulating the education sector so that that's not just a migration factory. I think that we also, this is where unions and the role of Jobs and Skills Australia and the Jobs and Skills Councils is important, because we need the data on wages and conditions and on compliance with labour standards to be being made in real time, so that we can properly assess, is this just becoming the new fast-track pathway to PR, which is not what it's meant to be. It's meant to be that you bring people in who have a desire and an interest in working in care, and they want to stay in that career for a long time, and that when they get PR, they stay in that industry. But they're not going to stay in that industry if they're being underpaid or they're being treated poorly. And that's where unions and other third-party actors are key to monitoring what's happening on the ground. Because is it just a shortage because of low wages and conditions? And I think this is something the previous National Skills Commission didn't do, that kind of sectorial case study-based approach. They just did macro quantitative analysis around what are the wages and conditions, what are the wages, and did recruitment surveys of employers to see if they're struggling to find staff. That didn't actually show why there was a shortage. And so I think Jobs and Skills Australia is going to be a key part of this puzzle to get the system working, to be properly assessing shortages and to linking it to wages and conditions in a sector.
I probably do have a bit of skepticism that Jobs and Skills Australia can ever identify shortages in the way they would hope, just on the data that's available. It is a really tricky job because, a lot of the existing surveys or assessments are based on, can I find a worker at the prevailing wage? And if the prevailing wage needs to rise, then that's not captured easily in those sort of surveys. I just want to quickly, before we finish, jump to a question we've gotten online, which is, should we be basically, if we're worried about underpayment, and we're worried about the concerns that this underpayment might affect the wages offered to younger Australian or long-term residents, is the solution actually just less low-skilled migration? Is that actually how we solve this problem? Should we be looking to reduce the number of low-skilled workers in Australia, which would run counter to the what we've just discussed on aged care?
So my view is that we've had an artificial distinction between high skill and low skill migration in Australia. And I think the fundamental question is whether there's labour market need and whether that labour market need is at the correct wage for that industry. And I think, I've been travelling around Australia speaking to farmers, and the fact that picking, packing and grading is work that Australians don't want to do doesn't mean that we should just shut down the horticulture sector nationally because we can't find the locals to do it. This is an industry that is reliant on overseas labour. And if the overseas workers are being treated well and paid appropriately, and we're monitoring and enforcing Australian law on those farms, then absolutely temporary labour migration works and should create pathways to permanent migration, because these are long-term needs in the horticulture sector. I think I don't have a view, and it was something we debated in the review about, should we just not have low-skilled labour migration? But that is divorced from the reality that often the stronger needs in our economy is around low-skilled work. But if we just rely on a revolving door of temporary migrants to do that low-skilled work, then we're embedding low wages and conditions, and we're not improving the situation over time.
No. Look, it's a really tricky issue, because as soon as you give pathways to permanent residency with a fixed number of permanent visas, then there's a question about who we give those visas to. We could obviously expand the size of the intake, but we've seen that, migration is contributing to other pressures in areas like housing. So there are flow-on questions about what that means for the design of your permanent visas. We don't want to necessarily become, quote unquote, a guest worker society, which is something that the review did certainly grapple with as well. Sharmilla, I want to come to you just because we've only got a couple of minutes left, and which is, I just want to, in a minute or so, can you tell us what is the thing that you most hope to see from the government to reduce exploitation of migrant workers?
So one of the big things is that we need an efficient, accessible and inexpensive dispute resolution mechanisms for workers to quickly recover all of their unpaid entitlements, whether that be wages or superannuation or other. So that will be a big change. So that would be the key change that we would be seeking, Brendan.
No, I think that would go a long way to helping solve the problem. The question is probably a little bit unfair, because I also think what we've found is you need to do all of these things. It's like a three-legged stool. Yeah.
Yeah, absolutely.
So we need to fix the visa rules. We need to offer those protections. We need to improve the enforcement of laws. And then we also need to offer ways of migrant workers and others to easily and simply be repaid what they are owed, because that itself will improve deterrence on employers. And obviously it's not all employers that are underpaying, but there's enough underpayment that there are enough employers that it's a problem. Look, I want to thank both of you, because we're going to run out of time in just a moment. I want to thank both of you for participating on the panel today. With respect to Grattan's own work, you can find our full report on the website at www.grattan.edu.au. The report is shortchanged, How to Stamp Out the Exploitation of Migrant Workers in Australia. I'd like to acknowledge the support of those on the panel who have contributed feedback to that report, as well as others that are experts in this area. And if you'd like to support the work of Grattan Institute, especially our work program on migration, you can do so at the website. All donations are tax deductible. It is near the end of the financial year. And Grattan's migration work is actually an example of where it's only possible due to the generous contributions from philanthropists. So the Scanlon Foundation in particular, without that support, we wouldn't be working on migration policy today. So I just want to say finally, thanks, Sharmilla. Thanks, Joanna. We hope to see some more action from government in this space over the course of the next little while. Unfortunately, I don't think we'll be not talking about this issue anytime soon, but hopefully we can start to make really meaningful progress here. So thanks, everyone, and thanks for watching.